5, 4, 3, 2, 1. Good morning, everyone. Thank you very much for attending this morning's workshop, limited workshop, related to docket number 2025-191A. And on December 8th, the clerk's office issued a notice of limited workshop asking interested persons to participate in today's workshop regarding proposed, potentially, Regulation 103-845, Sections E and F. Okay, we're live streaming this morning, so I'm not going to introduce my fellow coworkers because those of you who are in the hearing room can see and talk to those individuals. So we will proceed with me asking who is here representing Duke Energy Carolinas LLC and Duke Energy Progress LLC.
Good morning, Jocelyn. I'm Sam Wellborn on behalf of Duke Energy Carolinas and Duke Energy Progress. I believe on the line we should have Tekla Henderson and Lyle Treywick as well.
That's my understanding that both those individuals. Good morning, Ms. Henderson and Mr. Treywick, and thank you, Mr. Wellborn, for being here.
Thank you.
Dominion Energy
Morning,
South. Good morning. Good morning, Dominion Energy South Carolina Incorporated.
Good morning, Jocelyn. I'm Chad Burgess. I'm in-house corporate counsel for Dominion Energy South Carolina, and with me today is Michael Anselmo from the law firm of McGuire Woods, who serves as the company's outside counsel.
And Ms. Hutton, I see she's in the audience.
And I have failed to acknowledge Ms. Hutton. Ms. Hutton, who is sitting behind me, she's also in-house corporate counsel for Dominion Energy South Carolina. Thank you, Jocelyn.
Wonderful. Good to see all three of you. Next, Palmetto Broadband Coalition.
Good morning, Jocelyn. Annette Edwards on behalf of the Palmetto Broadband Coalition.
Good morning, Ms. Edwards. Thank you for being here too. South Carolina Department of Consumer Affairs.
Good morning, Jocelyn. Roger Hall on behalf of the department.
Thank you for being here too and participating. Next is Water Companies South Carolina Utilities.
Good morning, Charlie Twain.
Good morning, Mr. Terraini. Thank you for participating this morning. Piedmont Natural Gas Company Incorporated.
Good morning, Jocelyn. Jason Richardson, outside counsel for Piedmont Natural Gas of McGuire Woods LLP. I do apologize. I am traveling and going to have to step through TSA here shortly, so I may be in and out on connection, but appreciate the opportunity to be here.
Oh, yeah. Thank you. Thank you for participating. And last but not least, South Carolina Office of Regulatory Staff.
Good morning. Ben Muschin on behalf of ORS.
Good morning. Thank you, Mr. Muschin, for participating this morning. So everyone, just I know you all recall, but when the clerk's office issued the initial notice in this docket, which was July 10th, 2025, and Ms. McMullen, would you just display what I have on the desktop for just a second? We started with the document, if you recall, that looks like this, okay? And some of our staff got together just based on our reading of Act 41 and reviewed the procedural requirements based on our view, and then proposed some language. And so where we started was just for 103-845. There wasn't an E or an F. It was supplemental testimony and responsive testimony. And you all diligently read the information and provided substantive feedback, which we appreciate. And subsequent workshops, stakeholders' opinions varied from whether we need to include a regulation at all, whether the language of Act 41 needs to be further explained in the regulation, more detail provided, and others actually took the time and provided comments, which we genuinely appreciate. So this morning, I read the comments and understand the range of comments from, do we even need a regulation for responsive and supplemental testimony, to written comments that were submitted by Department of Consumer Affairs and Duke Energy Carolinas and Duke Energy Progress. And so there's a span right now. And of course, we're all most comfortable with, I think, the language that's in Act 41 at this point, which is why I sent the document to you that I did. I don't know if stakeholders, parties, if you have had a chance to talk more since the written comments have been filed, I'd like to just ask this morning, each party or stakeholder's position as to whether you think we even need a regulation at this point for responsive and supplemental testimony. That's first. If you say, okay, I think we do, perhaps should it include the language right out of the statute, which is the document that I do have copies. Can I get your help, please, Emily? Everybody, I don't know if you've met Emily Wilson, but she's our newest staff attorney, so I'm going to just ask her help for those of you who don't have copies. So should we track the language in Act 41? And the reason that I included also a rebuttal testimony is in the last draft, as you recall, there is a proposed regulation for surrebuttal testimony. That was my only reason for doing that. If it looks like this section D. Okay. So that's why I included the language from 58.3.140D. Thank you, Emily, for your consideration this morning. So does that make sense? All right. So may we start then, Mr. Welburn? Do you have an opinion you'd like to offer this morning regarding where we should go with these issues?
I have opinions, yes, ma'am.
Okay.
So I'll start with the answer to your question, which is that Duke Energy strongly believes that regulatory clarity is needed. I think that's evidenced by the continuing disagreement between the consumer advocate and Duke Energy. I think, again, if we stick with the language and the Energy Security Act, we will continue to have confusion and disagreement and a lack of clarity and fights in each and every docket before this commission, because there is clear disagreement between where the consumer advocate believes the Energy Security Act should be interpreted and how we believe it is appropriately interpreted. I have more comments, but that's my preliminary response to your question as to whether additional clarity is needed.
Okay.
In my view and in Duke Energy's view, simply grafting the Energy Security Act's language into the regulation wouldn't help.
Okay.
The intent of promulgating regulations by an agency is to elucidate and make clear where there may be ambiguities in the statute and to kind of fill in the gaps, right?
Mm-hmm.
That's what regulations are for. And prior to our engagement in these workshops and exchanging comments and discussions, I would have thought there would be little disagreement about what the General Assembly intended when it said the party with the burden of proof has the right, must be permitted to close its case, including the presentation of responsive testimony. I now see, based on our continuing exchanges with the consumer advocate and in these series of proceedings, that there isn't clarity as to what the General Assembly meant when it said what I thought was very clear language. So I'll get into my comments now, but that's my preliminary response. I think there's a clear need for elucidation based on the various arguments and positions that the consumer advocate has put forth in these series of workshops.
Okay, thank you.
And
no, you weren't done. Excuse me.
I'm not done. That was my warm up.
Okay,
that was my warm up.
Okay.
So, and I don't mean to, I feel passionate about these things because we've had this fight for years.
Okay.
The commission in docket 2021-291A opened a docket to quote, study and review pre-filed rebuttal and surrebuttal testimony. There was disagreement at that time and before that time as to what the role of surrebuttal testimony was to be. And I promise this is relevant. After taking comments, including from Duke Energy or as the consumer advocate, the commission, it issued order 2022-58. 2022-58. That was in February of 2022. We had already had the fight for years up to that date, but the commission finally said, "All right, let's put an end to this. Let's put this to bed." So almost 4 years ago, it issued an order, and in that order, it said, "Surrebuttal testimony should quote rarely, if ever, be necessary." End quote. Now, as y'all know, In spite of that very rare necessity, parties in practice file rebuttal testimony all the time. Now, I did research, and counsel for DCA, the consumer advocate, can correct me where I'm wrong. But in every case that I looked at in which they participated, they file rebuttal testimony, rarely if ever necessary. But DCA consistently has wanted the last word in these proceedings. And I get that. I understand that. They're the consumer advocate. They're supposed to advocate. But, and this is an important but, the General Assembly passed in May of this year the Energy Security Act. We paid close attention to this section, the section that we're debating. We paid very close attention to that section throughout the legislative process. The General Assembly, in our view, meant what it said when it provided the party with the burden of proof with the unequivocal right to close its case, including the presentation of responsive testimony. It doesn't say rebuttal testimony, as the consumer advocate has been arguing in these workshops. It says responsive testimony. Now, we are supportive of the proposed regulation as drafted and issued by the clerk's office on, I think it was December 8th, not this morning, but the draft regulation language that was circulated.
Yes.
We intend to support that language as drafted as it moves through the promulgation process. And we think it's perfectly aligned with the requirements and policy that underpin the Energy Security Act. Again, clearly there's disagreement between the parties. We think that some elucidation through regulation is appropriate and necessary. The DCA has argued that the regulations are not necessary, but their attempt to read any meaning out of that provision show exactly, again, why those regulations are needed. Because we're going to be right back here arguing the same thing that we've been arguing for 4 plus, 6, 8, 10 years. And it's something that, in our view, has been put to rest by the unequivocal right granted by the General Assembly through the Energy Security Act that the burden of proof must be permitted to close its case, including the presentation of responsive testimony. So again, I think I've flagellated the deceased equine, or I've beaten the dead horse, to borrow Ben's language, but we feel very strongly about this. We think the commission got it right. We think the clerk's office got it right with its December 8th, proposed language, and we continue to advocate for that being the right position.
Okay, thank you. Mr. Burgess, do you mind if I ask Mr. Hall just a question before?
We were actually going to suggest to let Mr. Hall go next, since I think that would help everyone.
Okay. Mr. Hall, may I ask you this?
Sure.
If an intervener files rebuttal testimony and the company or the applicant does need to respond, are you of the opinion that the applicant should be able to provide responsive testimony to the witnesses who basically provided the rebuttal testimony?
So I think it depends on what's in the rebuttal. I think we alluded to last time, if somehow rebuttal raises something that shouldn't have been raised, then the appropriate response is to strike it, not to allow a new round of testimony.
Or are you saying that's because rebuttal somehow addressed an issue that's not in rebuttal? Is that what you're saying? That's not in written rebuttal?
Correct.
Okay. What if rebuttal testimony, what if a commissioner asks a question that's a new matter?
I think we've talked about, and I don't have ball in front of me, there's existing rules that would allow that in certain circumstances, but it depends on what the information they're providing. So we've seen some of the case law cited in these comment letters, that essentially, if it's something that should have been in your case in chief, it should have been in your case in chief. You don't get to just bring it up because, we should have mentioned that before. So there are limitations in the case law and court rules. So I don't think there's a easy answer to your question.
Yeah, I was trying to, because I'm going to be honest with you. My other thoughts for wanting to come back just to Act 41 this morning, I'm going to be honest with everybody, is I was thinking about the person who's presiding on the bench. I don't want a regulation to be created either that ties the chairperson's hands at all, because we couldn't foresee everything that may happen today, if that makes sense. So All right. So, okay, did you answer my question? I'm treating you like a witness. Did you
I
answer
think it was an it depends.
It depends. Okay. So it depends. All right. Okay, I'm going to ask you another question. You say, Jocelyn, I don't want to approach this way. I have my own speech I want to give. Ms. McMullen, would you display, and then would you display what's on the, yeah, thank you so much. Okay, so this, Mr. Hall, what's being displayed is the December 8th filing, and then I had the section that, your notes, here they are. Your comments. Okay. Are you still of the opinion that E is just not needed at all? I know those were your comments here, but then your, I think what the clerk's office did is it used part of what you filed on November 4th. Page 7 of 7. Subject to the right of the party. Yes, this quoted portion. So subject to the right of the party with the burden of proof to present responsive testimony. And you indicated, well, we did. We included part of what you recommended at the very end. Subject to the right of the party with the burden of proof to open and close its case. So you would have stopped at case for that version. Do you see what I'm referring to? Instead of including the presentation of responsive testimony. I think that's where
that sounds familiar.
The difference is. Oh, here.
Yeah, and I think this reflects what I was saying just a minute ago about there's existing rules and case law, et cetera, that address some of these things and I don't want to rehash my prior comments. I think we stand by all of our prior comments.
Okay.
But there are limitations on what can be presented if it's, again, there's some case law quotes that's, yes, have the right to open and close in full and may respond in full, but may not introduce any new matter. So there are limitations on what can be said in this so-called responsive testimony. I think what we've said from the beginning is that the proposals that have been put out there do not recognize those limitations and seem to provide anything and everything,
okay,
as long as it's in response to something.
All right.
That's not always appropriate.
Okay. All right. What if the end of that sentence read, including the presentation of responsive testimony where appropriate? And I'm going to come back to you, Mr. Welber, just for you to consider.
And I think that's what that original language that we said subject to rule, whatever, 43J.
Yeah, 43J.
611.
That's recalling.
And those are the two that get cited in the case law that you've seen in various comment letters in this as well. So it always comes back to that either should have been, as long as it's not something that should have been their case in chief, or it doesn't introduce new matters.
Mm-hmm.
It's maybe clarifications or things like that. And again, with this idea that they have the right to open and close their case, what I would just say in response, what we've said before, is we've seen Duke throughout, and maybe Dominion 2 or other utilities, say, we want to present our rebuttal testimony last.
Okay.
I don't see any reason why what the legislature passed in Act 41 doesn't just accomplish that. You get to close it by presenting your rebuttal testimony last. I think that's a plausible reading of this, and like we've said before, if they wanted to say, you get a chance to respond to Sir rebuttal, there's plenty of opportunity to do that in Act 41. It wasn't done. I think there's plenty of reasons it may not have been done. I mean, you look at the sort of imbalance, we call this like an information imbalance, and the different opportunities that utilities have in these cases. They've got months, a year to prepare the case. They get their application, get their direct testimony, and they get rebuttal. Again, Sir rebuttal should be limited. We're not the only party that typically submits Sir rebuttal, but I don't remember the last time I saw a motion to strike Sir rebuttal either. So if it's something a new matter that comes up, again, court rules, case law allows a reply to that.
So, all right. When you say a new matter comes up, if a new matter is filed for some reason in surrebuttal, what I think I'm following you, what you're stating is the applicant or whomever else should then file a motion to strike that testimony if the surrebuttal testimony contains new matter, not surrebuttal and then a later supplemental testimony filing. Which,
yeah, I think supplemental is different. We've seen that plenty of
Yeah.
times where again there's maybe an error in testimony or some new information and adjustment. I think we just saw it recently in Duke's the Duke progress rate case, I believe, where even the initial revenue requirement was reduced in some supplemental testimony by $500,000 or whatever. So that's again new information.
Yes, sir.
I don't know. I was trying to see if I had it pulled up the original or what's currently proposed for surrebuttal testimony. I think there was some language. I don't think that's been in dispute. Do you have
Which one do you need?
that the commission staff proposed for surrebuttal?
Oh yeah. Hold on a second.
I can pull it up here too. I just don't remember
Well,
which notice.
the December 8th one, or the one today.
for surrebuttal testimony.
Oh, surrebuttal.
Because I think there's been some comments that
Here you go.
that additional language.
You can use this. Surrebuttal. Here you go. I'm gonna take off my notes.
Well, I have all the documents, so if you just tell me what date it was.
There it is, right there.
Yeah, so I mean, essentially, the commission's recognizing that's the language I was looking for. It's if there's new matters in rebuttal, and the commission may limit the scope of surrebuttal. And so again, it's providing that discretion that we said was sort of absent with this language around responsive testimony, responding to surrebuttal.
But it depends on whether or not a commissioner asks a question that perhaps was not covered in rebuttal, so it couldn't be covered in surrebuttal, but the witness is prepared to answer.
Yeah, and I think I said last time, there are opportunities again that already exist in court rules and case law that you can recalling a witness.
Oh. So you don't like it being called responsive?
I don't think responsive means.
I'm not picking at you.
I don't think responsive means. I don't think the language is clear. We think the language is clear that you can present your rebuttal testimony to close your case. That is your responsive testimony that you are allowed to close your case with under Act 41.
Okay. And so maybe what you're saying too, okay, follow me, Mr. Hall, just another scenario. What if the rebuttal is presented before the witness is allowed to, or the surrebuttal witness presents his or her testimony? Then you're saying that the company should ask the commission to be able to recall the witness who needs to be recalled to respond to that new matter that may have come about because of a commissioner question?
I think they can potentially recall a witness.
Okay. Well, we wouldn't call that responsive testimony?
In the context of what Act 41 means, I would have to look over that.
You have to look.
More,
okay.
But I mean, is it?
I'm not trying to put. I'm just trying
responsive?
to.
I suppose
Yes.
it is responsive.
Okay.
And if it's allowed under already existing rules, then they may be allowed to do it.
Well, would you just ask? Would you tell me if you would consider long term whether or not you think the phrase at the end, including the presentation of responsive testimony as allowed by commission, no, as allowed by law. That's all. That's the best I have right now. Just on the
I think that gets to what we propose as alternative language.
Okay.
Our original proposal sort of they weren't needed. If the commission thought they were needed, we provided some alternative language.
Okay.
Okay. Again, off the top of my head, it seems generally in line with what we said before that you pointed out, that subject to 43J and 611D.
Okay.
They may provide live responsive testimony where new matters or testimony arise at the hearing. So we would, again, we proposed that language. We would still say that that's perfect. I think there were some comments last time that were wondering about why we would include that. So I would assume that
those specific
some
sites.
of these other parties would have the same concern if it's just said subject to anything.
Yes, sir. About the specific sites.
So we would be. I think generally we'd be fine with that. I'd like to confer. With the department.
Okay. Perhaps for them to consider including the presentation of responsive testimonies allowed by law. Maybe. Okay. Mr. Welborn? I'm back. I wanted to make sure that I was following everything that Mr. Hall and his team, their position.
That's fair. I tried to follow Mr. Hall as well.
Okay. What do you think? What I asked Mr. Hall and his team to consider, including the presentation of responsive testimony, is allowed by law?
I don't think we would have any objection to that. I think that's exactly what we're trying to do, is effectuate the Energy Security Act. So to the extent adding as allowed by law helps get us across the hump, that makes good sense to me. I think Mr. Hall's reference to parties presenting rebuttal testimony last, that was a pre-Energy Security Act phenomenon, and that's no longer the right sort of modality for presenting testimony. And in fact, it doesn't make any sense to present rebuttal testimony after other parties present rebuttal testimony. So that can be dismissed, in my view, out of hand. But yeah, adding as allowed by law to the end of subsection E, I don't think I'll need to consult with the client on that. I mean, we all want to comply with the law.
Yes.
So yeah.
Yeah, everybody, please. I'm trying to see if what we can do today. Yep. Okay, now, Mr. Zelmo.
Yeah, thanks. And I appreciate coming back to us.
Yes, sir.
Ms. Boyd, we have a lot of complex issues that come before this commission in many, many different forms. I think this might be the most simple issue that's ever come before this commission. I'm not exaggerating.
Okay.
The General Assembly has said that the party with the burden of proof has the last word. Period. Full stop. That's the end of the inquiry. So if we can't respond, or the party with the burden of proof, I should say, can't respond to surrebuttal, we violate Act 41. Period. We can't do that. Okay. So the fact of the matter is, if surrebuttal is filed, the party with the burden of proof can, if they elect, without permission from anyone, respond to it to comply with Act 41. And then another point is, similar to Duke's comments about surrebuttal being filed sort of all the time, we have the same issue. If we haven't done the statistics like Duke did, but I can say with certainty that when the company files rebuttal testimony, we will say this does not raise new issues. It solely addresses issues raised in other parties' direct testimony. Mm-hmm. And invariably, we still get surrebuttal testimony. Okay, so the problem isn't Act 41. It really is abuses to surrebuttal testimony, which goes back to my point, which is the General Assembly solved this issue. The party with the burden of proof, whomever that is in whatever proceeding, gets to respond to surrebuttal testimony, period. And the regulation that staff, I believe through Duke comments back in December 8th, adequately and properly, I believe I think Duke agrees with this, covers the issues of what I just said.
Okay.
So happy to answer any questions.
Okay. So if you would talk to your team, please, sir, about we're just talking now at the end of Section E. Ms. McMullen, please, ma'am. 845 proposed Section E, the language could perhaps read, including the presentation of responsive testimony is allowed by law. That's what I asked Mr. Hall to consider and Mr. Welborn.
My initial thought on that is I don't think there's harm in adding that. I think it's superfluous language because Act 41 already says it. Mm-hmm. But again, if that gets us through the finish line, that is perfectly permissible.
Okay. All right. So, let me see. We'll finish. Dominion, Duke, Ms. Edwards.
Hey, Jocelyn, I can make it very simple. You said E.
Oh,
it's F, responsive testimony that we're talking about.
Okay,
right?
So that is the one I issued this morning.
Right.
This is from December 8th.
Oh, okay.
So that is the version that's on DMS from December 8th. This was after the last workshop where Department of Consumer Affairs filed comments, and then Duke Energy, you may recall seeing a document that looks like this. Duke Energy Carolinas.
I'm okay. As allowed by law, and that's final work. Thank you.
You're welcome. Okay, Mr. Hall, I'm going to come back to you in just a second. Mr. Taraney.
first of all, I have no doubt we'll be chasing each other around the maypole over this thing for the next 10 years, regardless of what we do today. But I think you've got to have something in the regulation that alludes to responsive testimony, because otherwise your regulation's just incomplete.
Yes,
and while we may all know about Act 41, somebody may wander in here and refer to your regulation on practice and procedure, understandably, and be ambushed by the absence of this thing called responsive testimony, whatever that means. Other than that, I'll just let other parties elucidate.
Okay, and we're going to come back to responsive testimony in just a minute. I want to talk to Mr. Hall again, and Mr. Weber in particular. Okay, Mr. Richardson. Mr. Richardson may be on his. No, he's still here.
Yes, ma'am.
Do you have any comments right now? Or at this
Nothing specific. Just to support the two companies' position.
Okay, thank you. How about you, Mr. Mushroom, at this point?
No comments.
Okay, thank you. Okay, now, Mr. Hall, I wanted to come back to you. Do you have any other regarding supplemental, and then we'll move to responsive?
I don't.
No. All right, thank you so much. Okay, Mr. Welburn, may we now move to responsive testimony? And I think you are going to say, perhaps, you like the December 8th version.
Yes, ma'am.
Okay.
That's right. For all the reasons I've stated, and I won't go back through those. To me, the two issues are interrelated, as between E and F, and I'm not going to restate what I stated earlier, but 100% agree with the December 8th version.
Okay. All right. Now, Mr. Hall, I am going to look at your comments again, if you don't mind. I put them somewhere. Mr. Hall, give me a second. Where did I put your comments? Oh, here they are. Out of mind, out of sight. Or out of sight, out of mind, I should have said. Okay, so I think, Ms. McMullen, would you display what I have on the document? Thank you so much. On the document camera. Sorry, I switched up on you here. Because I just want to be able to compare. Ask Mr. Hall. Based on what we found. So it appears, Mr. Hall, that the December 8th version does not include the language at the beginning, subject to the Rules of Civil Procedure, Rule 43J, and then the Rule of Evidence 611D. But the proposed language begins with the party with the burden of proof may present responsive testimony. Well, no, you had live. The new version, or the December 8th version, just says responsive testimony. It omits the word live. Where new matters or testimony arise, and this says are introduced at the hearing. All right, so kept at the hearing. That remains, including new testimony solicited upon cross-examination from the parties or questions from the commissioners. So it's really the live responsive testimony. The word live is no longer, it was not in the December 8th version, and the reference to one rule, rules of civil procedure and rules of evidence. Thank you, Ms. McMullen. Okay. Would the previous suggestion at all regarding just reference to as allowed by law help at all there?
I mean, I think it addresses what we said before with those two rules. There were comments. I don't know if Duke has an opinion on those here. I know Dominion had wondered about the inclusion of those prior. I don't know that they took a strong stance on them or not. And the live, I think, was just, you pointed out live wasn't in there. That was in the original. That was in the proposal that we were replying to at the time.
Oh, okay.
I believe that was the commission staff's first proposal had that.
I apologize.
And we had some concerns with the word live that maybe was reading too much into it, but again, to provide an alternative, we were fine including it if it referenced those two rules.
Okay, so live doesn't make any difference to you. You're more concerned perhaps about the reference to the rules.
It's the limitation. I mean, I think what our comments come back to is that there are still limitations on what can be presented,
Yes,
even
sir.
if you have a right to close your case.
Okay.
It doesn't let you present anything and everything you want. It needs to be appropriate testimony that, isn't something that should have been included originally. I've been sitting here trying to think of an example. Unfortunately, I don't have a great one, but there was a new expense or a new justification for an expense. That's something that should have been included. It's, again, this avoiding this element, of surprise, and I'm sure people will say that, well, that's the same thing. That's why we should get to respond to sir rebuttal. But there are existing rules and case law. Our Supreme Court has looked at this. I mean, it's been analyzed. It's just, there are limitations on what you can provide in
Yes,
that
sir.
responsive testimony.
Yeah, I understand what you mean. I do. I understand your perspective. I do. Are you okay with the same concept that I asked you to talk to your team about too? Similar language in both sections, as appropriate, as allowed by law.
Yeah, I mean, we prefer probably. I mean, like we said originally, the direct reference to those two rules.
Yes, sir.
Are subject to those rules and any other laws, I suppose. But we'll take it back.
Okay.
But again, we propose those two rules because those are the rules that come up. Those are the rules that have, our courts have looked at and said this is important. I don't think Act 41 should be read to somehow say those rules are no longer applicable in commission proceedings. So.
I think I remember Mr. Treywick saying, Mr. Wilburn, at the last one, that his reason, or perhaps, this is what I wrote, Mr. Treywick. If I misrepresent what you meant, please let me know. I wrote, South Carolina Rules of Civil Procedure 43J may conflict with Act 41 provisions. South Carolina Rules of Evidence does not need to be included as the chair retains discretion over the admission of evidence.
Yes, ma'am. And to that point, there are other provisions apart from, Rule 43J that may be applicable. And so as allowed by law, to the extent that helps, should cover the gambit, right? Yes, ma'am.
Not something. Something.
Ask me something.
If those two sections remain, plus as allowed by law, is that too restrictive?
I'd like to shake your hand right now and be done with this, so we don't have to have another one of these workshops. I'll sign a paper right now on behalf of my client. But yes, ma'am, I think that would get us over the hump.
That would get us where we need to go.
Yes, ma'am.
Okay.
Jocelyn, can I add just one thing on that?
Okay.
I think you accurately said what I said, but when you only include two things,
yes, sir.
The canon of construction is that implies the exclusion of others.
Okay.
So I think doing that could limit the chair's discretion, which would have the opposite effect of what I think Mr. Hall intends. So as required by law, I believe would be appropriately broad. And I don't think we need to account for every single evidentiary objection in a regulation, right? Like parties can make objections under the applicable rules of evidence and rules of civil procedure. So that was really the only point I was trying to make, in addition to the ones that Ms. Wilburn made. So I hope that's helpful.
Yes, sir. I understand. Yes, sir, Mr. Terani.
Well, I just have a question, maybe for you and the party. Is anyone here arguing that this responsive testimony should be allowed to introduce new matters?
We're not, for clarity purpose. I mean, it's responsive, right? You're responding. So that's not case in chief. That's not new. Right. That's responsive.
That's kind of what I thought. I just wanted, let's go ahead and get it on the record. I mean, I don't see how I would.
Okay. Okay, Mr. Wilburn. So it sounded as if you may be okay. You're not sure yet with the beginning of Section E reading, subject to South Carolina Rules of Civil Procedure 43J and South Carolina Rules of Evidence 611D, and
I can unequivocally say that is not, what we're supporting. What we're supporting is the limited edition of as allowed by law at the end. To Lyle's point, and Mr. Trawick's point, to the extent we start isolating certain rules of civil procedure and other nits and nats, we tend to exclude other things that may equally apply, which could hamper, in fact, the DCA's ability to lodge a proper objection in a future case. So I'd rather, us keep it open to the extent we can, recognize that as allowed by law should cover the gambit and just move that way.
Okay.
And Jocelyn, just for clarity, I mean, I tend to agree. I just would like, again, I don't want to commit the department here, though. And I don't know if Mr. Wellborn is willing, if he has that authority to say that, that's fine. But I just would like to confirm with the PCA that that's acceptable.
Okay, so
I believe, like you said, I agree with Mr. Wellborn that it does address our primary concern there.
Okay, all right. Okay. Mr. Anselmo, do you have any comments?
No.
Thank you. Ms. Edwards?
No.
Okay. I'll come back to you, Mr. Hall. Mr. Terani, any other comments?
No, ma'am.
Thank you. Mr. Richardson?
No further comments. Thank you.
Okay, thank you. Mr. Mushkin?
No comments.
No comments. All right. And Mr. Hall, do you have anything else?
Nothing further.
Okay. So I'm sorry, Mr. Wellborn, that these are painful. I really am. I hate to tell you, we start again in February with another round of 5-year review, so I don't know what to tell you.
They're only as painful as we make them,
okay.
Jocelyn. And I, for what it's worth, so appreciate your patience and willingness to work with us. Y'all have been troopers through all this. So.
Well, and the issue is too, the whether you all have to. Sometimes I consider it from staff's perspective. We learn a lot during these workshops because we're not able to talk to you all just when we, like we're able to speak here. So we appreciate when you come in and participate and tell us your thoughts and your perspectives. It's very helpful for the entire commission. So these are very valuable to the commission. And so when you do, even when you have disagreements, it's helpful. And that's the truth. All right. So I will proceed, everybody, with the proposed regulations on what you've seen, what we've discussed today, the document from December 8th, and unless someone has an issue or wants to speak now and let us know you don't think that the rebuttal that I included from this morning is necessary, I will not include it. I just included it because Sir rebuttal is the proposed section D, in the December 8th draft. Just so you know. But that's December 8th plus what we've discussed today is what you will see in the proposed regulation. You may have additional comments. The notice of drafting is on the website. I think they're due like January 6th. So whatever other additional comments you have, we will definitely consider before filing the proposed regulation. All right. Thank you so much, Mr. Wellborn, Mr. Trawick, Ms. Henderson. Thank you, Mr. Burgess, Mr. Anselmo, Ms. Hudson. Thank you, Ms. Edwards. We appreciate you, Mr. Hall. Thank you, Mr. Terani, Mr. Richardson, and of course, thank you, Mr. Mushkin. We'll see you all soon.